Page 2. Section 1 provides a detailed statement of the case that the government intends to prove at trial. This includes the conduct alleged in the superseding indictment, as well as other categories of evidence that the government intends to present in its case in chief. This detailed statement reflects the Supreme Court's ruling that presidential immunity contains an evidentiary component, ID, which should be addressed at the outset of a proceeding. Page 5 of 165. A. Formation of the conspiracies. Although his multiple conspiracies began after Election Day in 2020, the defendant laid the groundwork for his crimes well before then. Leading into the election, the defendant's private and campaign advisors, including P6, then a private citizen, and P2, the defendant's campaign manager, informed him that it would be a close contest and that it was unlikely to be finalized on Election Day in part because of the time needed to process large numbers of mail-in ballots prompted by the COVID-19 pandemic. They also told the defendant that the initial returns on election night might be misleading, that is, that he might take an early lead in the vote count that would diminish as mail-in ballots were counted because his own supporters favored in-person voting, while supporters of his opponent, Joseph R. Biden, favored mail-in ballots. Privately, the defendant told advisors including campaign personnel, P7, a White House staffer and campaign volunteer, and P8, the vice president's chief of staff, that in such a scenario, he would simply declare victory before all the ballots were counted and any winner was projected. Publicly, the defendant began to plant the seeds for that false declaration. In the months leading up to the election, he refused to say whether he would accept the election results, insisted that he could lose the election only because of fraud, falsely claimed that mail-in ballots were inherently fraudulent, and asserted that only votes counted by Election Day were valid. Page 6 of 165. For instance, in an interview on July 19, 2020, when asked repeatedly if he would accept the results of the election, the defendant said he would have to see, and it depends. On July 30th, despite having voted by mail himself earlier that year, the defendant suggested that widespread mail-in voting provided cause for delaying the election, tweeting, "With universal mail-in voting, not absentee voting, which is good. 2020 will be the most inaccurate and fraudulent election in history. It will be a great embarrassment to the USA. Delay the election until people can properly, securely, and safely vote." In an interview on August 2nd, the defendant claimed, without any basis, that there is no way you can go through a mail-in vote without massive cheating. At a campaign event in Wisconsin on August 17th, the defendant told his supporters, "The only way we're going to lose this election is if the election is rigged. Remember that. It's the only way we're going to lose this election. So we have to be very careful." In his acceptance speech at the Republican National Convention on August 24th, the defendant said that the only way they can take this election away from us is if this is a rigged election. On October 27th, during remarks regarding his campaign, the defendant said, "It would be very, very proper and very nice if a winner were declared on November 3rd, instead of counting ballots for 2 weeks, which is totally inappropriate. And I don't believe that that's by our laws. I don't believe that. So we'll see what happens." The defendant said this despite, or perhaps because, his private advisors had informed him that it was unlikely that the winner of the election would be declared on November 3rd. Page 7 of 165. By October 2020, P1, a private political advisor who had worked for the defendant's 2016 presidential campaign, began to assist with the defendant's re-election effort. 3 days before Election Day, P1 described the defendant's plan to a private gathering of supporters, and what Trump's going to do is just declare victory. Right? He's going to declare victory. That doesn't mean he's the winner, he's just going to say he's the winner. After explaining that Biden's supporters favored voting by mail, P1 stated further, "And so they're going to have a natural disadvantage and Trump's going to take advantage of it. That's our strategy. He's going to declare himself a winner." Immediately following Election Day on November 3rd, the defendant did exactly that. As his private and campaign advisors had predicted to him, in certain states, the defendant took an early lead on Election Day that began to erode. At approximately 11:20 p.m., Fox News projected that Biden would prevail in the state of Arizona, and according to campaign advisor P4, he and the defendant were shocked and angry at this development. As Election Day turned to November 4th, the contest was too close to project a winner, and in discussions about what the defendant should say publicly regarding the election, senior advisors suggested that the defendant should show restraint while counting continued. Two private advisors, however, advocated a different course. CC1 and CC6 suggested that the defendant just declare victory. And at about 2:20 a.m., the defendant gave televised remarks to a crowd of his campaign supporters in which he falsely claimed, without evidence or specificity, that there had been fraud in the election and that he had. 1. This is a fraud on the American public. Page 8 of 165. This is an embarrassment to our country. We were getting ready to win this election. Frankly, we did win this election. We did win this election. In the immediate post-election period, while the defendant claimed fraud without proof, his private operative sought to create chaos, rather than seek clarity, at polling places where states were continuing to tabulate votes. For example, on November 4th, P5, a campaign employee, agent, and co-conspirator of the defendant tried to sow confusion when the ongoing vote count at the TCF Center in Detroit, Michigan, looked unfavorable for the defendant. There, when a colleague at the TCF Center told P5, "We think a batch of votes heavily in Biden's favor is right," P5 responded, "Find a reason it isn't. Give me options to file litigation, and even if it be's." When the colleague suggested that there was about to be unrest reminiscent of the Brooks Brothers riot, a violent effort to stop the vote count in Florida after the 2000 presidential election, P5 responded, "Make them riot, and do it." The defendant's campaign operatives and supporters used similar tactics at other tabulation centers, including in Philadelphia, Pennsylvania, and the defendant sometimes used the resulting confrontations to falsely claim that his election observers were being denied proper access, thus serving as a predicate to the defendant's claim that fraud must have occurred in the observer's absence. Page 9 of 165. Contrary to the defendant's public claims of victory immediately following Election Day, his advisors informed him that he would likely lose. On November 7th, in a private campaign meeting that included P2, P3, P4, and White House staffer P9, who came to serve as a conduit for information from the campaign to the defendant, campaign staff told the defendant that he had only a slim chance of prevailing in the election, and that any potential success was contingent on the defendant winning all ongoing vote counts or litigation in Arizona, Georgia, and Wisconsin. Within a week of that assessment, on November 13th, the defendant's campaign conceded its litigation in Arizona, meaning that based on his campaign advisor's previous assessment, the defendant had lost the election. That same day, in an implicit acknowledgement that he had no lawful way to prevail, the defendant sidelined the existing campaign staff responsible for mounting his legal election challenges. From P2, P3, and others who were telling the defendant the truth that he did not want to hear that he had lost, the defendant turned to CC1, a private attorney who was willing to falsely claim victory and spread knowingly false claims of election fraud. As the defendant placed alternating phone calls to P3 and CC1 throughout November 13th, P1 informed CC6, another private campaign advisor, of the change, writing, "Close hold, don't tell anyone Trump just fired P3 and put CC1 in charge, and you are to report to CC1." Page 10 of 165. When CC6 asked if P2 was gone too, P1 replied that they all report to CC1 and that P1 had made a recommendation directly that if CC1 was not in charge, this thing is over. Trump is into the end. The next day, consistent with P1 description, the defendant announced his staff change by tweet, writing, "I look forward to CC1 spearheading the legal effort to defend our right to free and fair elections. CC1, P10, P11, CC3, and P12, a truly great team, added to our other wonderful lawyers and representatives."